Good afternoon on the East Coast, good morning on the West Coast, and good evening in parts beyond. I'm Joel Hellman. I'm Dean of the School of Foreign Service, and I'm glad to have you here for another SFS Fast Break. As I've mentioned before, when we first started this series, we thought it would be an occasional one-off, maybe once or twice a semester when a major event happened that we would be able to bring together our community and with an expert faculty member to discuss the implications. Well, we've been doing these fast breaks almost once a week now. Just gives you a sense of the scale and scope of what's going on. And today, uh, in what is, I think, something that we certainly didn't expect, we ourselves at SFS are going to be the subject, or at least part subject, of a fast break as we talk today about some of the constitutional issues around free speech on campus, what it's meant for SFS, but the broader issues, what it means for universities. And with us today, we couldn't be happier to have the inimitable Tony Arend, Professor Anthony Arend. Many of you know, as so many of our SFS colleagues know him extremely well. He has played so many roles across the school. He's currently chairman of the government department in the College of Arts and Sciences, but also an SFS professor. He was a former vice dean of the faculty and graduate affairs at SFS. He was a former director of MSFS. But of course, for today, it is his expertise in the area of international law that we are going to rely upon to try to help us parse through what the legal issues are in terms of the engagement on campus and what this means and what the implications are. But let me start, because this does impact SFS, rather than begin with questions for Tony, which I'll have plenty of, and I would ask you to put your questions and questions for Tony Arend in the Q&A function, which I will be monitoring and Tony will be monitoring. We will be choosing and integrating questions from the Q&A. We're not going to be reading out questions necessarily. We'll be summarizing them and trying to bring them naturally into the conversation and keep a flow. And we'll keep this to the half hour that we have managed this for all of our SFS fast breaks. But let me start first with an opening to say what's happening with SFS. And a case that has hit the headlines. It's been on almost every major news outlet. There is a postdoctoral fellow, Dr. Badar Khan Suri, who has been with us since 2022. He has been a researcher working on conflict and conflict mediation in South Asia, in particular in Afghanistan and Iraq. He has been a postdoctoral fellow at the Center for Muslim-Christian Understanding, and he has been teaching a course on majoritarianism and conflict resolution in the ACMCU, as we call it. As many of you know, he was detained by DHS, by ICE, at his home last week in front of his family and his children. He was taken very, very quickly out of the jurisdiction from Northern Virginia, where his home was, to Louisiana first, and now to Texas. We were explicitly informed that he was being held under a statute, which Tony is going to talk about, from the Immigration and Naturalization Act, which gives the Secretary of State the power to revoke the status of individuals that he deems are a threat to U.S. foreign policy interests. And that was the statute on which he was taken. There has been a lot of conversation, if you will, on social media, a lot of information and misinformation put out on this case. And so I want to just set the record straight on a few things that we can say because we know he's been a member of our community. You will have seen in other cases that some of the people who have been charged under this statute are people who have been leading protest movements, who have been, especially at Columbia, the case of Mahmoud Khalil. He has been a student leader. He has been leading the protests. And those protests, as you know, has essentially brought Columbia to a halt. At Georgetown, there are quite a few differences to this case. First and foremost, let me say that Badar Khan Suri has not been engaged in any meaningful or significant way in campus protest activity, not a leader of campus protests. His activity was largely confined to his social media postings. And people on this call and others, and we've seen plenty of posts on it, may find some of his social media posts objectionable, even offensive. We're not here to talk about the content of his posts. We're really talking here about the right to make those posts in his private capacity on social media. He doesn't teach on these issues. He's not been engaged in protest activity on these issues. And as I said, in contrast to Columbia, our campus has also not been racked by the level of political protest, even the violence that we have seen in other campuses. So this is a case in which his detention and possible deportation proceedings are largely based on his speech acts and his family connections, which have been raised in the social media. Which raise, of course, sort of significant questions about what is the nature of the legal case to be made against those who might be engaging in their constitutionally protected right to free speech. He is a J-1 student visa holder. What are the rights of guests to the country to engage in free speech? And I think those are the issues in which his detention is really based on. What I want to do first is actually talk a little bit about the nature and the legal basis of that detention and the possible deportation proceedings. And then I also want to talk about the impact that this has been having on our campus. And I want to spend some time talking about this because what everyone thinks about the speech acts that he made, about his own personal political leanings, I can tell you, and we'll talk more about this with Tony, that it has had a chilling effect on the willingness of everyone in our community, faculty, staff, and students, but especially, of course, those who are on some form of visa status, feelings of concern about their rights to speak on campus, their right to speak in class, and their right to engage in private speech in social media. And I think that is something that deeply concerns us because it is core to our mission. One last thing I want to say before I get to Tony, for those of you who are kind of concerned about a member of our community who is being detained and who is being threatened with deportation. He has a wife who is a student at Georgetown University, an American citizen of Gazan background. He has 3 children. I want to assure you that as this case goes forward, the university, first, to care for a member of our community who has been impacted, is working closely with the family to make sure that the family is getting the legal advice it needs to support his case and to defend him in this case. We are ensuring that the family is sort of supported in the sense that they are not going to be impacted financially or others by this detention and possible deportation, as we would for caring for the whole person for any member of our community. And we have been providing the support for the family as they deal with a very, very difficult set of circumstances. So we've been public about that support. We've been public about the concerns that we have about free speech on this campus. And we will see what we can do as a university to protect that important right on our campus. So with that, let me now move to Professor Arend, Tony, as everyone knows him. Tell us about the legal issues of this case. Give us some background. Help us understand what we need to know about the constitutional issues associated with this.
So thank you very much, Joel, and I want to thank everybody for joining us on this issue, obviously an issue that is very much going on right now at Georgetown and affecting the Georgetown community. So for those folks who've taken either my international law course or my con law of national security law, you're going to hear some things that are familiar. I'm going to start with international law, with this basic proposition of international law, and that is every sovereign state has the right to make decisions about whom it lets in and whom it does not let in. So we begin with that basic sovereign right. Now, the reason I start with that is because when the United States was formed, if you look at the Declaration of Independence and the Constitution, one of the goals of the framers was to make sure that the United States maintained and established a position of sovereignty in the world. And what that meant was that the United States was going to be entitled to all the rights under international law, all the rights that sovereignty entailed, and of course, all the obligations. Now, under international law, even though states had a right not to admit anyone they wanted, once they did admit a non-national, that person had certain due process rights under international law. And so for someone who has studied an international law class, they'll hear about all these rights of due process that are established under international law. So that's the background under which the Declaration of Independence was promulgated and the Constitution was adopted. Now, what does the Constitution say? We want to start with Article 1 of the Constitution, which is the provision of the Constitution that gives rights to Congress. Interestingly enough, Article 1 says nothing about immigration explicitly. It does say that Congress can make rules concerning naturalization, and the courts have traditionally said that Congress has the right to make laws which are necessary and proper relating to immigration. So this falls initially in Congress's court. Congress has the right to make laws concerning immigration. Article 2 of the Constitution, which deals with the rights of the president, empowers the president to enforce the law. The president also, in connection with the president's role as commander-in-chief, is also seen as having certain roles specific to foreign policy. So that's our constitutional framework. We might want to have more in the Constitution, but that's what's there. So pursuant to Congress's power, Congress has adopted the Immigration and Naturalization Act, which has been amended a number of times. And there is a provision of the Naturalization and Immigration Act which has been applied in this particular case. And if you'll forgive me, I'm going to read it. Dean Hellman made reference to it, but it's just a very short provision. An alien, so an alien is a non-national, whose presence or activities in the United States, the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States, can in fact be deported. Now, a couple of things here. It is the Secretary of State, so it's not the President, not the Director of Homeland Security, but as the Secretary of State has reasonable ground to assert that this person will have a potentially serious effect on foreign policy. Now, there are actually exceptions in the Immigration and Naturalization Act, and one of them connects to exactly what is alleged to have gone on here. It says one of the exceptions when the Secretary of State should not deport the person relates to when past, current, or expected beliefs, statements, or associations, if such beliefs, statements, or associations would be lawful within the United States. Now, what that suggests is if a non-national is in the United States and is exercising things that are protected under the First Amendment, that you should not be able to deport that individual. Okay, that would seem to apply here. But there's another exception. It says the Secretary of State may nevertheless seek to remove such an alien if the Secretary determines that, and here's the quote, that the alien would compromise a compelling United States foreign policy interest. If the Secretary of State makes such determination, however, the Secretary of State must notify specific committee chairs in the House of Representatives and the Senate. All right. Now, let me unpack a little bit of what's going on there. The Secretary of State, Marco Rubio, determined under this provision of the Immigration and Naturalization Act that this individual should be deported. Okay, that's kind of the first step because the individual's actions would somehow compromise foreign policy. As far as I know, the Secretary of State did not lay out the specific compelling reasons and did not notify the specific committee chairs. Now, you may say, well, okay, fine, but he still has the right to do it. Yes, but what is at issue here is due process of law. The Secretary of State has to lay out the specific reasons, communicate them to the chairs of the intelligence committees, and say why this person is being deported. Without doing that, the Secretary of State is not following legal procedure, is disregarding due process of law, which is required under the Immigration and Naturalization Act and is also required, I would add, under international law. This is why the attorneys have petitioned for a writ of habeas corpus and are asking a federal judge to determine whether the Secretary of State has in fact followed the procedure and articulated the reasons why the individual is being deported. You just cannot simply say, you're out of here. You have to follow procedure. Now, to some people, that may sound like a technicality, but these provisions of the law, these requirements of due process are there to protect abuses of the law. And I think we've seen this in other examples with respect to other cases where people seem to be running loose and fast over the legal process. So that's a bit of a long explanation,
Now,
but I wanted to make sure everybody sort of understood where we are, and I'm happy to answer questions about that, and I'll go back over to Joel.
yeah, what some of the questions that are coming in. You talked about the procedural issues. Let's talk about the substance of the case against him and what this means for the Secretary of State's rights. As people have asked on the chat function, the Q&A, and it is in the writ of habeas corpus that have been sent by the legal team of Badar Khan Suri, is that the case against him is that he has family connections to Hamas, which is a designated terrorist organization. I will say that family connection is via his father-in-law. And the father-in-law once was, in an earlier incarnation, a member of an advisor to Hamas government. That was over 10 years ago. And actually, the father-in-law actually came out against the October 7th attack. But putting that aside, the family connections to Hamas is one aspect of what they are claiming, and his speech acts. Again, there's no activities that they can point to in the way that you could in some other campuses that have impacted or might be seen as illegal or might have impacted campus security. Putting the procedural issues aside, is that sort of sufficient to judge as a potential foreign policy risk?
So as I read the law, the answer is yes, because it would be the determination of the secretary. And again, as Dean Hellman said, I'm not saying that's good or bad. I'm just saying in terms of a legal analysis, because the Secretary of State can make that determination. The Secretary of State needs to articulate those reasons. And if the Secretary of State said, I'm making this up, because his father-in-law had previously been with Hamas, there are likely to be continuing connections with Hamas and others, we regard that as a threat to the foreign policy of the United States. That would be, under the way the law is written, a sufficient reason. Now, do I like that or not? But that would be a sufficient reason under the law. The key thing here is, but the Secretary of State would have to articulate that. And I actually think the court could say, we don't think that's a sufficient reason, although the court is more likely to defer to the executive branch on this. But I don't think that even family ties would be precluded based on the way the law is drafted.
Now, you probably sort of saw an interesting article in which it was President Trump's own sister who actually declared this section of that act unconstitutional, which didn't then hold up to scrutiny. Tell us a little bit about her objections to it and whether or not those objections might be seen in further review of this.
So I think that would be a reasonable claim. A reasonable claim would be to say, well, wait a minute. When individuals have been admitted to the United States, again, you don't have to admit anybody, but when they've been admitted to the United States under the Constitution, they have the same rights of free speech as anyone. That's the traditional understanding. And you could say that, therefore, this provision of the Immigration and Naturalization Act would be violative of First Amendment rights, which we traditionally guarantee. Now, that has been held, the provisions of the INA have, in fact, been held as constitutional. And even though it may grate against my sense of what free speech would involve, my guess is that if this goes up for higher review, so if the case is challenged based on constitutional issues, the likelihood is, irrespective of what the district court rules and the Circuit Court of Appeal rules, it seems to me to be likely that on this issue, the Supreme Court would defer to the president's discretion as delegated in the act to the Secretary of State.
Well, as one questioner asked, does there have to be some kind of reasonability criteria in which you make those judgments? Is it, I mean, and what I actually saw in President Trump's sister's opinion was, given the fact that the Secretary of State can sort of say just about anything in some way impacts American foreign policy interests, it means, and I'm going to get to this issue in a moment, that it doesn't give us a foundation for how we can engage in speech when any act however reasonable or unreasonable, can be seen as a threat to a foreign policy.
So I agree with that. However, I'm not sure the courts do. And what I would say in this regard is as follows. While I believe it is subject to review, and undoubtedly attorneys for the Department of Justice are saying this is non-reviewable, I do believe it's subject to review. It does use the word reasonable. I think the judge has to make that determination. It's entirely possible a judge could say, well, this is absurd, this is unreasonable. However, there is a long-standing tradition of courts deferring to the executive branch in matters that deal with foreign policy. I mean, we can go back to the Curtis Wright case, for example, from the 1930s. We could go back and even look at something like the steel seizure case, where the court articulates times when you so my sense is that in this particular area, the courts are likely to defer. And I think where they wouldn't is if there were no reasons given, they would say, well, you have to make some argument, you have to articulate something. But if there's something that on its face looks reasonable to the court, I think they're inclined to defer to the executive branch. We see that all the time. We see that all the time in a variety of cases where when you're dealing with foreign policy as opposed to domestic policy, the courts are more inclined to defer to what the executive has ruled for good or ill. But that's what we tend to see. We also tend to see Congress typically unwilling to adopt legislation which seems to restrict the president. And so over years, it looks like there's congressional acquiescence in allowing the president to take such authority, and courts have taken note of that.
Well, someone has asked, is it a slippery slope to say that it's not just sort of issues that might risk foreign policy concerns for the U.S., but actually just differences that one administration has in their views of what foreign policy should be versus others? I mean, isn't that a slippery slope?
Yes, that is the problem. That is indeed the problem. Is you could have someone come in to the country, and what they articulate under one administration is consistent with views of foreign policy. A new administration comes in, and those views are not consistent with the administration's views of foreign. That does mean that, yeah, which again points to the problems of the law, but also this longstanding practice of deferring to the president. It also raises the question as to why one might contend that the law is unconstitutional. And I think there's a strong argument to be made there. My guess, and what I'm really trying to do here is sort of read the current Supreme Court based on the direction in which the current Supreme Court has been moving. My guess is they're going to defer to the executive in this area. And my guess is that they're going to be able to point to a lot of cases, not just cases under the Roberts courts, where the Supreme Court has deferred to the executive in this area.
So what I'm concerned about is the consequences for speech on campus, not only for aliens, for those who are here as visitors, but in fact, what we are seeing, and I have to be very frank about this, the effect that we have seen already on our campus as well as we hear on other campuses, certainly for any international student on a student visa, is, I can only describe it as fear. Fear to speak in class, and worries that what they say in class might be used against them, might be a source of doxing, might be even reportable to the Department of Education for as long as that exists. Fear of using private social media channels, their private speech, because that could be used against them. I've heard concerns from faculty members who worry that they may be implicated, especially those who are on work visas here, that may be implicated by this. Given the dynamics that you're talking about, Tony, and the impacts that this could have on free speech, at one point, did the constitutionally protected rights of free speech and the chilling effect that this might have on free speech weigh into the calculations of how this is going to be reacted in different parts and branches of government?
So I want to begin by saying I agree completely. And also note, in giving my legal analysis, I'm trying to sort of tell you where I think things are and where things are going. That doesn't mean any of this is good as a matter of policy. And I will say that there has been a tremendous chilling effect that has taken place. And it's taken place with respect to students, faculty not wishing to share their views, people using Signal, although that can get you in trouble, but people using Signal to communicate something that they might have otherwise done as a text or an email, and law firms being targeted, people's security clearances being taken away, people who were involved in the January 6th prosecutions being fired or removed. Somebody mentioned in the chat the inspectors general. I would also submit the judge advocate generals of the military being removed. These all have horrific effects in chilling free speech, in chilling freedom of assembly, in basically chilling things which are fundamental rights. A lot of these things I think are unconstitutional, and a lot of these things I believe are going to be resolved by the courts. But that's going to take a while. And in the meantime, I think we're not in a good place. And I think it's because of the policies that the administration has undertaken. As I said, they're going to win some of these things legally. That doesn't mean it's good policy. They're going to lose, I think, a lot of these things legally. But even then, in the meantime, students, faculty, staff members, lawyers, members of the federal government, I think are going to be living in fear that anything they say will be taken against them. And this applies not just to non-nationals, but to nationals as well. So I do think there is a tremendous chilling effect, and I'm truly worried by it. As I said, the law is going to help us in some cases, but the law won't help us in other cases. Something can be, the phrase is, something can be lawful, but awful. And we're seeing a lot of that.
And is there any fear for actual American citizens?
Yes, yes. I mean, I think part of the, so American citizens have freedom of speech. We understand that. But one thing that concerns me is we do have laws against providing material support to terrorist organizations. Now, my interpretation of that would be if I gave money to a terrorist organization or I otherwise provided material support. I'm worried that something that someone says, even an American citizen, something that someone says could be interpreted as providing material support. And even though you might win it in a court case, if I'm suddenly charged with that based on something I've said or someone I know, then I could be detained, or I could be in a situation where I'm going to have to spend thousands of dollars on attorney's fees. So that's going to have, I think, a horrific chilling effect on American nationals as well. And I think it already has. And just in talking to my colleagues, people are saying, oh, be careful what you say. You got to watch what you say, and so on. And I think it's terrible. In my lifetime, I think that this was before my lifetime. The only thing this reminds me of is the McCarthy period, where people were afraid that they would be rallied up based on guilt by association or something they've said. And I think in many respects, this is worse than that because of the technology and because of social media.
Well, there have been many questions about how Georgetown is responding to this, and let me say a few words about that. Tony could add as well. Let me say first and foremost that the university has, throughout the response to the terrorist attacks on October 7th, to the war in Gaza since, and to the devastation that that's caused in Gaza, the university has had a very consistent approach. We have and have always had a policy on speech and expression. We didn't change it as a result of this crisis. It has served us well. What we have seen over the time is we have protected the rights of individuals, faculty, students, and groups on campus, subject to that policy, which is to ensure that everyone on campus has the right to speak, engage, organize, protest even, as long as they don't prevent us from the core business of our university. That has meant, and many of the comments already on the Q&A and the chat, that has meant an uncomfortable campus for many students, Jewish students and Muslim students alike. But we have been very consistent in enabling students, enabling faculty, enabling speakers to bring different views on campus. What it has done, I think, at Georgetown, and I would argue, is that it served us well in keeping a campus that has been open, deliberative, that has not descended into chaos, as we have seen in some other institutions. It has enabled us to have some difficult conversations that made a lot of people uncomfortable, but we have kept to the core principle of preserving that space for the dialogue, preserving that space for the discussion. And I think this case makes that dialogue more difficult, makes that space for deliberation more difficult. And as a result, is deeply troubling to us across Georgetown. It's come from the interim president, from the deans and others. Whatever one's view are on these issues, whatever one's views might be about the kinds of speech acts that Khan Suri is alleged to have made, or his family connections, we feel the core principle of a university is to preserve that space for dialogue, preserve that space for engagement, and to ensure that our community members all feel that they have the ability to participate and engage in that dialogue. That is a principle that we will continue to stand up for. That is a principle which is leading us to ensure that we are open in public about this case, despite, I'm sure, the very different views that people might have on the nature of the case. But we think this is core to what a university is all about. And we will, and I know that some people have expressed concerns, in the tradition of cura personalis, ensure that we are doing everything that we can to support all of our community members. But in this case, given the detention, given the impact on his family, given the impact on his life and his career chances, we feel that it's very important for Georgetown to speak up for the ability of our faculty members and our community members to speak freely on campus. We wanted to give you a sense of what's happening here. We wanted to give you a deeper sense of what the issues are legally, as well as what's happening here on campus. I am sure you will hear more about this case. It's going to be in the media as we follow it through. I know we couldn't get to all the questions and comments, and I know that people have very strong views on this, and I appreciate you joining us to hear what the legal issues are and what the campus issues are. And we will continue the dialogue, and we will continue the SFS Fast Breaks on the issues of the day as they keep coming fast and furious. But let me thank you, Tony Arend, for being part of the conversation. Let me thank all of you, the hundreds of SFS alums who've joined us in concern and have strong feelings about what we ought to be doing on campus and how we ought to be preserving the values and principles of our university. And we will see you again on another Fast Break as these issues come to the fore. Thanks very much. And thank you, Tony Arend. Take care.
Joel.